Welcome to the shorthand study classes. Get ready for freehand progressive shorthand dictations. Start. We shall first of all deal with the submissions of Mr. Thakur with regard to the junior clerks and class 4 employees of the Supreme Court staff. The Learned Council has placed much reliance upon the judgments of the Delhi High Court in revising the pay scales of certain categories of Class 3 and Class 4 employees as stated herein before, granting the pay scales of rupees 400, 600 and rupees 300, 430 respectively to LDCs and Class 4 employees staff. It is submitted that the Delhi High Court was fully empowered under Article 226 of the Constitution to issue appropriate writs if, in its opinion, the recommendations of the Third Pay Commission as adopted by the Government of India and as referred or reflected in the revised pay scales of 1973 insofar as these are related to the staff of the Delhi High Court amounted to discrimination and consequently violated Article 14 of the Constitution of India staff. Council submits that the specially petitions filed by the government against the judgments of the Delhi High Court have been dismissed by this court. The Delhi High Court judgments revising the pay scales of its employees, including the pay scales of the LDCs and Class 4 employees, have attained finality and operate as res judicata between the parties, namely the employees of the Delhi High Court and the Union of India staff. It is submitted that this court was fully justified in passing the interim orders on the basis of the judgments of the Delhi High Court, which had become final and conclusive between the parties and binding on them, and that the pay scales granted by this court by the interim orders were consonant to justice and equity staff. It is urged that it was not open to the Fourth Pay Commission while revising the pay scales of the staff of the Supreme Court to take a pay scale or pay commission or lower than the one prescribed by this court by the interim orders as the basis for revision, as that would amount to negativing and neutralizing the effect of the orders passed by this court staff. It is submitted by the Learned Council that the recommendations of the Fourth Pay Commission, if allowed to prevail, would result in the reduction of the salaries of the junior clerks and Class 4 employees to a lower level than what they were receiving on the date of the revision, and it would be highly discriminatory and violative of Article 14 of the Constitution. The question whether the High Court judgments relating to the LDCs and the Class 4 employees are right or wrong may not be necessary to be considered staff. But the relevant question that requires consideration is whether the said judgments of the Delhi High Court have become final and conclusive and binding on the parties staff. In case it is held that the judgments have not attained finality and do not operate as res judicata between the parties, the question as to the correctness of the judgments may be considered staff. Let us therefore advert to the contention of Mr. Thakur that the Delhi High Court judgments have become final and conclusive between the parties and operate as res judicata staff. It is the contention of the learned Attorney General that the judgments of the Delhi High Court are erroneous on the face of them, inasmuch as by these judgments the Delhi High Court has granted to the restorers oblique LDCs and the Class 4 employees Punjab pay scales as also the central DA star. It is urged by the learned Attorney General that such judgments should not be given effect to so far as the junior clerks and Class 4 employees of the Supreme Court are concerned. Star. It is submitted that because the specially petitions against the Delhi High Court judgments have been dismissed by this court, the judgments may be final between the parties, but the benefit of that wrong decision should not be conferred on the employees of the Supreme Court or persons similarly situated. Star. The Delhi High Court has made an error and that error should not be perpetuated. Star. Para. We are unable to accept the suggestion of the learned Attorney General that reconciliation can be made by freezing the pay scales of Supreme Court employees, which they are getting by virtue of the interim orders of this court to be adjusted or neutralized against the increments. Star. It is not the business of this court to fix the pay scales of the employees of any institution in exercise of its jurisdiction under Article 32 of the Constitution. Star. If there be violation of any fundamental right by virtue of any order or judgment, this court can strike down the same, but surely it is not within the virtue or to be adjusted by virtue of an order. This court can strike down the same, but surely it is not within the province of this court to fix the scale of pay of any employee in exercise of its jurisdiction under Article 32 of the Constitution. Star. So far as the judgments of the Delhi High Court are concerned, they do not infringe the fundamental rights of the employees of the Supreme Court or and of the petitioners who are the petitioners before us in the writ petitions, and so the question of considering whether the judgments of the Delhi High Court are right or wrong does not arise. Star. If the judgments of the Delhi High Court had in any manner interfered with the fundamental rights of the petitioners before us, in that case the question as to the correctness of those judgments would have been germane. Star. The petitioners, far from making any complaint against the judgments of the Delhi High Court, have strongly relied upon them in support of their respective cases for pay hike, and accordingly we do not think that we are called upon to examine the proprietary rights or propriety or validity of the judgments of the Delhi High Court. Star. Para. Now it is the case of justice and jury. Star. But the cases of LDCs and Class 4 or Class 5 employees are really to be taken care of. Star. Any judgment of the High Court delivered in an appeal made under Section 130 or on a reference made under Article 130 by the Appellate Tribunal before the 1st day of July 2003 on a reference made under Section 130A, in any case which on its own motion or on an oral application made by or on behalf of the party aggrieved immediately after the passing of the judgments, the High Court certifies to be a fit one for appeal to the Supreme Court, or any order passed before the establishment of National Tax Tribunal by the Appellate Tribunal relating, among other things, to the determination of any question having a relation to the rate of duty of customs or to the value of goods for the purpose of arrangement or assessment. Start. Para. Now, the batch of the cases relating to cess and other taxes on minerals, Bracted Validation Act 1992, herein referred to the question for consideration is by the aforesaid Act what in fact has been validated. Is it only that the taxes on mineral or minerals already realized under the invalid law or the right to levy tax and realize the same which became due up to 4th of April 1991 star. Several cases arising from different states have been tagged on to the main matter arising out of the judgment of the Patna High Court were listed together, but we think it appropriate to decide the Bihar matter so that the law laid down therein would be followed in other cases. Star. Incidentally, the earlier judgment of this court arising out of the said Validation Act in relation to the levy of tax on minerals in the state of Tamil Nadu in the case of state of Andhra Pradesh is required to be reconsidered, and it is for that purpose these cases have been referred to a three-judge bench. Star. In the case arising out of the judgment in Patna High Court in SLP Bracted Civil number 13102 to 13107 of 1996, the state through the district mining officer is the petitioner, and by the impugned judgment the High Court thou has upheld the validity of the Validation Act. Star. Thanks.